Flemings. And Mr. Flemings, and is it the same in each case, or was it an agreement for a dismissal in one? Or
It was intended to run concurrent for 8 years.
okay, and did you do two pleas? Okay, they're both here. Okay, I'm sorry, I just saw one. Mr. Flemings, in cause number 24, DCCR 2144, you're charged with the second-degree felony offense of assault on a peace officer from September 11th of 2024. That indictment alleges that you were previously convicted of possession of a controlled substance, a third-degree felony, September 27th of 2023. And what that means is that if you go to trial and you're found guilty and that prior offense is true, the range of punishment would be between that of a first-degree felony, which is between 5 years and up to 99 years or life in prison. Do you understand?
Yes, ma'am.
Sorry to interrupt.
Yes.
I believe the defendant's criminal history lends itself to being a habitual offender, and I have every intention of filing the habitual offender notice.
Okay, and Mr. LeBlanc, did you go over that with him as well?
No, you're not talking about that outside.
25
25 to 99? Yeah.
So, the state has information, he says, that you have more than one felony conviction from before. So if that's true, if you have at least two that are from different dates, and you are found guilty, that changes this from a first degree up to a habitual offender status, which is a minimum of 25 years in prison up to 99 years or life. Do you understand?
Yes, ma'am.
And in cause number 24 DCCR 2145, you're charged with the state jail felony offense of injury to a child, elderly, or disabled individual from September 11th of 2024. That indictment alleges several prior state jail felony offenses. And when I say several, I mean 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 prior state jail felony offenses. It does not allege those prior regular felony offenses, but if you have, again, two regular felonies that are sequenced, not on the same day, in that case, it would make it a second-degree felony offense for punishment purposes, which has a punishment range between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
Judge, I'm sorry to interrupt again. I want to correct the record. I misspoke. Mr. LeBlanc and I talked about it being enhanced to a regular first degree.
Okay.
5 to 99. We
Okay.
didn't specifically talk about the 25 to 99. I don't want to.
Y'all did it, but you do have the prior, so it could be. Y'all just didn't discuss it.
Yes, ma'am.
Okay, so, but you understand now, I've admonished you, and you understand, and you know what your history is. If you have a prior felony, two prior felonies that aren't state jail, and you're found guilty, then the minimum punishment is 25 years. You understand?
Yes, ma'am.
And that's on the assault. Other range of punishment in the injury to a child would be 2 to 20. You understand?
Yes, ma'am.
Okay, and so I have here on the computer plea bargain rejections that you've signed with Mr. LeBlanc that shows that the district attorney's office has made an offer of 8 years in each of those cases to run concurrently, which means at the same time. You have every right to reject that and have your cases set for trial. I just want to make sure you understand what your possible consequences are if you go to trial, what your options are. Do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your cases set for trial?
Yes, ma'am.
All right, we'll get it set for trial. Mr. LeBlanc will begin preparation for trial. You can go back with the bailiff. All right, ma'am, you're Casey Bean. And will your client waive the formal reading of the indictment in each case? Ms. Bean, in cause number 23, DCCR 2068, you're charged with theft of property in an amount more than $2,500 with previous convictions, which is a third-degree felony, from April 6th of 2023. The indictment alleges you were previously convicted of theft September 4th of 2014, December 22nd of 2015, December 6th of 2017, December 7th of 2018, and June 24th of 2019. How do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? And then in cause number 23, DCCR 2069, You're also charged with theft of property with previous convictions in an amount more than $2,500 from June 25th of 2023. And how do you plead to that charge? That's also alleges all of those same prior offenses. And are all of those same prior offenses true? And in this case, did you enter your plea of guilty freely and voluntarily? And because you did what they charged you with. In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? You also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Bean is not competent?
No, Your Honor.
All right, ma'am. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 23, DCCR 2069, find sufficient evidence to find you guilty, and at this time find you guilty of theft with previous convictions in an amount above $2,500. Sentence you to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that for any time that the law gives you the right to receive. In addition to that, I will give you credit for any from the date of indictments in each of these cases, which is from November 29th of 2023. So you will receive credit from November 29th of 2023. Y'all have marked that on here as 624 days. I'm going to assume that y'all did that math correctly. But it's for sure from the date of indictment on each case. Do you understand? And then in cause number 23, DCCR 206, which one did I just do?
6-8, was it?
Just did 9.
Well, I did the plea papers, but then which one did I make the finding
I'm
on?
not sure.
That I made the finding? Okay. In 23 DCCR, you good? Sorry. 2068, I'm also going to find sufficient evidence to find you guilty, and at this time find you guilty of theft with prior convictions in an amount above $2,500. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Correction. You will also receive credit on that for any time that you've been in custody that the law gives you the right to receive, and also specifically from the date of indictment, which is November 29th of 2023. These two cases will run concurrently, which means together at the same time. I have handed you the trial court certification in each case that shows these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. Right? Good luck to you, ma'am. You can go back with the bailiff.
And a GPS. That's your bond. Yes, ma'am, we'll just need to.
Right. Perfect. So Ms. Pugh, Mr. Jeffries has been appointed to represent you. He's just been given, he's trying to get caught up real quickly on all the information and the discovery in your case. I'm going to reset your case so that he can get all of that. Once he gets it, he'll be out there to go over it with you, and we'll see if we can get an announcement at the next court date.
Respectfully, Your Honor, I do not agree to comply with any of your appointed court agents, considering that their first duty is to the state.
I understand. We've had this conversation before.
And for your record, I'll be representing myself.
So if you want to represent yourself, there's some things. Ms. Pugh, stop talking over me. If you stop talking over me, if you want to represent yourself, then there is a process that we have to go through, and we'll do that today. If that's what you want to do, we'll get your case set for trial, and we'll go forward that way. It is highly inadvisable for you to represent yourself. Lawyers have many, many years of training. They understand the law. They understand how a trial works. But what happens when you're in a trial and you represent yourself, you're expected to know and follow all of the rules of evidence, all the rules of procedure. And so you're really at a disadvantage if you don't know those things. And so you have to do everything just like the assistant district attorney would. And if you don't, you're going to be in front of a jury and it's going to show, and it's just not going to be, it usually does not work out in your benefit. But I have to go through with you some questions first before we do that. And then if you still want to do that, then there's a couple of things couple of options, and we'll go over those as well. Okay. So I am supposed to ask you, I'm going to go through these questions. I need you to answer them if you want to represent yourself, because this is required. All right. So have you ever studied the law?
Yes, I understand.
Okay. Have you ever represented yourself before in any kind of criminal matter? Okay. Do you understand the charges against you?
I'm never been accused of that.
Okay. And so do you know, and we've gone over before, I think, what the range of punishment is if you're found guilty on a jury? Do you know what that is? Let's see. Hold on a second. Let me pull you up here. We'll go over that again as well. The date of that allegations from June 22nd of 2021. And what that means is if you're found guilty, that the range of punishment that the jury could give you is between 2 years as a minimum punishment up to 10 years in prison, anywhere in between. Do you understand? And you answer out loud just for the record.
Do I understand? No, I don't understand.
What do you know about that?
I don't understand, Your Honor.
So here's the thing. If you want to represent yourself by law, you have to be able to understand these things. Otherwise, I've got to appoint an attorney for you. So you can't just say, I want to represent myself because I don't like the attorney or I don't like the process. This is the process that you're in. You live in Texas, you live in the United States. This is the law that applies to your case. So what do you not understand about the range of punishment if you're found guilty? And I'd be glad to explain it.
I don't understand because I have no idea anything wrong.
That's what a jury's for, right? And so if you say you're not guilty, then you go in front of a jury and they determine after they listen to the evidence if you're guilty or not. That doesn't have anything to do with if they find you guilty, you understanding that they could send you to prison for between 2 years and up to 10 years. Do you understand that part? What are you, yes or no? No, you don't understand that. So, Ms. Pugh, it's my understanding, I'm not going to allow you to represent yourself because you don't understand the law and the process. So we're on question number 4 out of 15 that I'm supposed to ask you. So Mr. Jeffries is going to stay on your case.
I don't know when Mr. Jeffries on my
I don't care what you want at this point. You can't do it. All right, you can go back with the bailiff. I'm done. Go back with the bailiff.
It's not on my case.
Go back with the bailiff.
It's not on my case.
Welcome to the criminal appointment list.
Yeah, fine, Judge.
This was not meant to be any kind of punishment, I promise. So Mr. Jeffries, get ready like you would. Probably it's going to go straight onto a jury,
Right, I would
and
assume.
we'll just get it figured out that way. All right.
Thank you, Judge.